Secretary Mayorkas, Florida's Attorney General has sued the Department of Homeland Security in the Northern District of Florida, asserting that the policies of your administration violate existing federal law. Federal Judge Alan Weatherall, who has heard evidence and testimony related to your policies, described your parole with alternatives to detention policy as follows. The evidence establishes that the administration have effectively turned the southern border into a meaningless line in the sand and little more than a speed bump for aliens flooding into the country by prioritizing alternatives to detention over actual detention and by releasing 1 million aliens into the country on parole or pursuant to the exercise of prosecutorial discretion under a wholly inapplicable statute without even initiating removal proceedings. Thereafter, after additional proceedings and evidence and testimony, the judge heard about your parole with conditions revision, which allows illegal immigrants to be paroled into the U.S. under the expectation that they will check in 60 days and receive a notice to appear at a hearing where we can initiate removal proceedings in court. And there, the judge noted that all totaled, only 18% of the aliens released under the parole with conditions policy after it was enjoined by the court have been issued a notice to appear and placed in removal proceedings. The additional 82% are either awaiting the issuance of an NTA or their whereabouts are unknown. Secretary Mayorkas, can you tell us as we sit here today, where are the people who have entered this country and been released under your, what you refer to as a parole program, where are they today?
Congresswoman, the individuals who are released, because we do not have the detention capacity, we are not funded for the detention capacity to detain everyone. But let me assure you that individuals who pose a threat—
Do you know where they are, Secretary Mayorkas?
Congresswoman, if I may, I want to assure you that individuals who pose a threat to public safety or national security are detained. That is how we prioritize our detention authorities. Otherwise, we place individuals who are not such a threat on alternatives to detention.
And do you know where those individuals are?
Those individuals are—
That would be a yes or no, Secretary Mayorkas.
And those individuals are supervised—
And I'll take it that in this case you do not. Now, about those who do not show up for failure to appear proceedings, for these notices to come to court, what are the consequences that those individuals face?
Those individuals face the consequence of apprehension and removal.
Is it not true that it would be necessary to know who they are and where they are in order to actually initiate removal proceedings from the United States?
There are those individuals whom we do know where they are, and we do initiate removal proceedings. And if individuals abscond, which is a concern that long predates this administration, Congresswoman, we have had absconders for many, many administrations. We have between 11 and 12 million undocumented people. When those individuals are apprehended, they are also subject to immigration.
Secretary Mayorkas, what I will note is this. In addition to it being clear that the department has failed to timely respond to requests for information and data about the policies of this administration and the status of all of these individuals who have been released into our country, it is also clear from reviewing a record of the proceedings in the Florida federal court that the department is failing to comply with orders of that court. And with that, Mr. Chairman, I yield the balance of my time
Would the
to the chair.